The genesis of the case can be culled out from Exhibit P1 dated 5th October 1991, filed by one Srimati Vatsalabai, wife of Chandrasekhar Kattimani, who was examined as PW1 before the trial court. Shorn of unnecessary details, the case of the prosecution was that ever since the marriage of PW1, which was 15 years ago, prior to the date of occurrence, namely 5th October 1991, she was living at the village Bardal. Her husband got 5 elder brothers, including the deceased Channabasappa Havappa Kattimani, that they were all living separately. Though he was playing a leading role in the affairs of Harijangeri, which is a Harijan colony, by amicably settling the disputes between different persons living in that colony, that about 20 years prior to the occurrence, one Amogi, son of Ningappa Kamle of Anchutagi village, came and settled at Bardal and started living in Harijangeri, who also started mediating between the members of persons living in the Harijangeri, which in course of time created a difference of opinion as between her brother-in-law Channabasappa and the said Amogi. According to PW1, her brother-in-law felt that Amogi was not following a proper course while mediating between the parties, and thereby injustice was being caused, which ultimately resulted in ill will having been developed as between both of them, and on some occasions resulted in quarrels as between them. Next para. On the morning of 5th October 1991, when PW1 was in her house, she learned that about 7 a.m. on that day, her brother-in-law Channabasappa, his son Sadashiv, and their men assaulted Amogi, and thereafter at about 8 a.m. she heard a noise of people from the side of her brother-in-law's house, pursuant to which, when she, along with her co-sister Subhadra, PW2, and others, reached the house of Channabasappa, she saw A19 and others were in the process of setting fire to the house of Channabasappa, while accused 16 and others were aiding other accused with salt, kerosene, oil, and firewood. It was also stated that the male accused were throwing firewood, kerosene, oil, and salt on the doors of the house, and there was lowering inferno from the house. PW1 also stated that persons who were inside the house were crying for help. While the said action of setting fire to the house of Channabasappa was going on, the accused also stated to have instructed others to set fire to the adjacent house, apart from preventing anyone from proceeding near the firing house. Every attempt of PW1 and others who were standing nearby to help the victims from getting rescued was of no avail, as they were all threatened by the accused of dire consequences and that they would also meet with the same fate. Next para. It was stated that as many as 10 persons, including Channabasappa, who rushed into his house in order to escape themselves from the onslaught of the accused, when they approached them, and who got inside his house and bolted it inside, were burnt alive by the accused by bolting the doors from outside and by setting fire to the house in all directions with the use of kerosene, firewood, and by throwing salt, whereby infuriating the fire to the peak. It is stated that the police reached the place of occurrence at around 9:15 a.m. and arrested A1 on the spot, and subsequently arrested all the other accused, and that after the arrival of the police, the other accused escaped from the spot, whereafter by summoning the fire brigade from Jabalpur, the fire was doused and the bodies of the 10 victims were recovered. The post-mortem was held on the spot, and thereafter the challan was laid before the learned First Additional Sessions Judge, Jabalpur, wherein the judgment of acquittal came to be passed. The division bench, having reversed the said judgment and imposed the conviction and sentence as noted above, the appellants are before us. Next para. We heard Mr. Rajesh Mahale, Learned Counsel for the appellants, and Ms. Rashmi Nandakumar, Learned Counsel for the state. Though Mr. Mahale appeared on behalf of some of the appellants, but on our request, he argued on behalf of the other appellants also. Next para. At the very outset, it must be pointed out, though the sequence of the events narrated above disclose that ill will between the deceased Channabasappa and Amogi was growing for quite some time before the occurrence. On the date of occurrence, that is 5th October 1991, the action of Channabasappa along with his son Sadashiv, who was also killed in this occurrence, stated to have caused some injury on the said Amogi around 7 a.m. on the day at his place, which enraged the son of Amogi and the other appellants who took it in the affront, and in that pursuit the appellants along with the other accused stated to have marched towards the house of Channabasappa in an aggressive mood, carrying weapons and fearing serious consequences. Channabasappa and 9 of his supporters, who were all killed in the occurrence, entered the house of Channabasappa, got them bolted inside to escape from the onslaught of the appellants. Unfortunately, it came handy for the accused to bolt his house from outside, and by setting fire to the house on all sides ensured that none of the inmates were able to get out of that house and save their lives. Next para. When as many as 28 persons were involved in that process at the early hours of the morning of 5th October 1991, it transpired that before any police force could come and rescue the victims, in a matter of about an hour and a half, the fire set by the appellants to the house of Channabasappa completely engulfed all those who were inside the house, charred to death. The medical evidence in the form of post-mortem report have confirmed the manner in which the victims died by fire. As far as the distance between the place of Amogi and the place of occurrence is concerned, it is stated to be just 2 furlongs, which could be covered in a matter of a few minutes. The police station is stated to be in a distance of about 8 kilometers. The complaint was recorded at 9:45 a.m. at the instance of PW1. There was also information furnished to the police at around 9:50 a.m. by PW23 at the police station, who was aged about 100 years on the day. Next para. Earlier on the day, A11, who was owning a jeep, stated to have carried Amogi after his assault by Channabasappa and his men and arranged for shifting him to the hospital at Jabalpur, who was also present in the police station at around 8:15 a.m. At his instance, crime number 133 of 1991 was registered in the police station as against Channabasappa and others for the assault on Amogi. Next para. In the above stated background, the High Court, while dealing with the appeal, has found that the evidence of PW1 along with PWs 2, 4, 5 and others, who were all eyewitnesses to the occurrence, sufficiently demonstrated before the court as to the manner in which the setting fire to the house of Channabasappa after they entered the house and bolted inside were surrounded, and the bolting of the house outside by the accused persons, and the manner in which the house was set on fire as well as the adjacent house, and also how the accused ensured that none of the victims who entered the house of Channabasappa were allowed to escape from the clutches of the accused and got themselves charred to death at the hands of the appellants. The High Court, having noted the charge against the appellants, namely 147, 148, 302, 436, 504, read with 149 IPC, after analyzing the evidence of the eyewitnesses, made a note of the various specific overt acts referred to by each of the eyewitnesses vis-a-vis the concerned accused by setting out a chart in paragraph 24 of the judgment, which runs to 14 pages. We find that the High Court took pains to make note of the various details with reference to the sequence of events spoken to by the eyewitnesses, specific role played by such of those accused who contributed their mite in setting fire to the house of Channabasappa, as well as the adjacent house, and thereby ensuring that none of the victims who entered the house of Channabasappa were allowed to escape from the clutches of the appellants and other accused, and ultimately met with their death. Next para. Having regard to such detailed analysis made by the division bench by making specific reference to the eyewitness account supported by the medical evidence, we are of the view that there is no scope for this court to make any further analysis in order to find out whether any of the appellants could be exonerated of the charge found proved against them. However, Mr. Mahale took strenuous efforts to contend before us that at least insofar as A11 and A23 were concerned, it could be said that they were not present at all at the place of occurrence, and therefore even with the aid of 149 IPC, the offence as against both of them cannot be said to be made out. In the first instance, when we consider his submission with reference to A23, appellant number 16, we find that he has already withdrawn the appeal, and therefore we do not find any necessity to consider his case. We are therefore confining ourselves to A11. The contention on behalf of A11 was that after the assault of Amogi by the deceased Channabasappa and his man at 7 am, A11 shifted the injured Amogi from the said place of occurrence and arranged for his transportation to the hospital at Jabalpur, and also simultaneously went to the police station and lodged a complaint which came to be registered as crime number 133 of 1991. A11 was stated to be present in the police station at 7:45 am for that purpose. PW23 Havappa also went to the police station after he witnessed setting of fire to the house of Channabasappa by around the same time. It has come out in the evidence of PWs 43, 48 and 50 that A11 was at the police station at 7:45 am initially, and going by the versions of PW 50, he was present in the police station up to 8:15 am. Again, going by the version of PWs 43 and 48, when PW 23 went to the police station, who was present in the police station till PW 50 left the police station, which was stated to be at 9 am. A11 was present inasmuch as, according to PW 43, A11 on hearing the complaint of PW 23 relating to the firing of the house of Channabasappa by the accused, A11 slapped PW 23 at the police station when the time was noted as 9:10 am. Again, PW 48 in his evidence stated that A11 was present in the police station at 9 am. Next para. The above evidence disclosed that A11, who went to the police station at 7:45 am, was found present in the police station at 8:15 am, and again between 9 and 9:15 am. As against the above evidence available through PWs 43, 48 and 50, The evidence of PW1 and other eyewitnesses disclose that A11 was found to be extorting the other accused at the place of occurrence with all vehemence at his command for setting fire to the house of Channabasappa by issuing different orders, such as for bolting the house of Channabasappa from outside, throwing salt and kerosene into the burning house, and also issuing such other directions to ensure that the house of Channabasappa is set on fire totally, with 10 of them inside the house, and every one of them ultimately met with their death. Next para. The learned counsel, Mr. Mahale, while appraising the version of PWs 43, 48 and 50, submitted that A11 was present at the police station at 7:40 am, 8:15 am, as well as between 9 and 9:15 am, which as spoken to by the above witnesses, who were all police personnel. There was no scope at all for A11 to be present at the place of occurrence as spoken to by other eyewitnesses. It must be stated that the police station was hardly 8 kilometers away from the place of occurrence. A11 had a jeep at his disposal, and it was he who organized for shifting the injured Amogi to the hospital and also preferred the complaint with the police relating to crime number 133 of 1991. It can be stated that immediately after the assault on Amogi at 7 am, A11, who seems to have been interested in the welfare of Amogi, took every effort to save him from injuries sustained by him, and also file appropriate complaint relating to the said incident with the police, which exercise he was able to successfully carry out. However, when we considered the evidence of the other witnesses who have consistently referred to the presence of A11 at the place of occurrence and the nature of activity indulged in by him, and also the act of A11, who was present in the police station when saw PW23 making a complaint in the police about setting of fire to the house of Channabasappa, got enraged and went to the extent of slapping him, unmindful of the fact that PW23 was an old man aged more than 100 years, who stated to have fell down as a result of such harsh behavior of A11. Since the setting of the fire to the house of Channabasappa occurred at 8 am, if A11 had no hand in it, there was no reason for him to get enraged when PW23 reported the firing incident to the police. Therefore, the conduct of A11 in having sharply reacted towards PW23, and that too by slapping him in the presence of police, only shows that he played key role in the setting fire to the house of Channabasappa as spoken to by the eyewitnesses. Therefore, it is quite apparent that while on the one hand the grievous attack on Amogi cannot be said to be justified, A11's mind set to take revenge at those who caused the said attack on Amogi cannot also be justified. Therefore, when the distance between the place of occurrence and the police station was hardly 8 kilometers in the village, such a distance could be covered in a matter of a few minutes in a jeep, in any case within 10 or 15 minutes. Therefore, in the absence of any concrete evidence to show that as between 7:45 am and 9:15 am, during the entirety of the said period, A11 remained only inside the police station and did not move out of the said police station, it will not be safe to simply go by the version of PWs 43, 48 and 50, who referred to his presence at the police station at specified hours, that is 7:45, 8:15, 9 am and 9:15 am, and thereby hold that A11 could have never made himself present in the place of occurrence in between those hours. Next para. Therefore, when we analyze the evidence of other eyewitnesses, we find that they were very categoric in their statement about the manner in which A11 was moving here and there at the place of occurrence, actively involving himself in issuing commands to other accused in the process of setting fire to the house of Channabasappa and ensured that the said house was completely burnt with all the 10 victims inside. We are therefore convinced that the conclusion of the division bench in having found A11 also guilty of the offence for which he was convicted was fully justified. We therefore do not find any scope to deal with A11 differently. Consequently, the appeal fails and the same is dismissed. All those appellants who were granted bail by an order dated 11/12/2009, their bail bonds shall stand cancelled and let them be secured forthwith and imprisoned to undergo the sentence awarded by the High Court as confirmed by us. As at our request, Mr. Mahale appeared for those accused who were not otherwise represented for his valuable assistance to the court. As an amicus curiae, we direct the registry to pay him a fee of Rs 10,000.